Go ahead and call the meeting to order, and T-Cole will go ahead and conduct the roll call of members.
Okay. If you can't hear us for some reason, please try and let us know as far as committee members. Again, we appreciate everybody being here. We understand that this is our last time meeting with this committee, and it's been a pleasure getting to know each and every one of you. Getting ready with our roll call this morning, Sheriff Roy Boyd.
Here.
Chief Jaime Ayala. Chief Bill Avera.
Here.
Yes, ma'am. Paul Christ. Chief Solomon Cook.
Here.
Okay. Bob Lydia. Chief Ronald Phillips. Constable Derek Rose. Marvin Riles.
Here.
Chief Derek Watson.
Here.
John Wilkerson. We have a quorum.
And Sarah Beth, I believe Chief Ayala is going to join us shortly. He's in a city council meeting right now.
Did they call your name?
Mr.
Yes, sir.
Yeah, Mr. Liddy is here as well.
Oh, okay. Thank you.
Thank you. All right, with that done, we'll move on to opening remarks. Just like say, it has been a pleasure working with everybody, and hopefully we'll have a product that will be satisfactory so that we can move forward. With that said, we'll move on to item number 2, which is review and take action on meeting minutes from January 16, 2024 advisory committee meeting. Discuss and take action on any other advisory procedural parliamentary matters if necessary. Should all have a copy of the minutes. And actually it was the 9th is when it was in Edinburgh, Texas. So if y'all have reviewed, or if y'all review that real quick, and then if we have any changes that need to be made, and then see if there's a motion to accept the minutes as presented.
Chief Abraham, move, we accept the minutes as presented.
We have a motion, we have a second. Do we have any discussion? If not, we will, all the minutes are approved, and we'll move to item number 3. Discussion and take action on matters related to developing minimum standards with respect to the creation or continued operation of a law enforcement agency based on the function, size, and jurisdiction of the agency as established under Texas Occupational Code 1701.163. This includes the review, discussion, and action on the first item is the matrix for the creation of a law enforcement agency. As y'all can see, we have an updated matrix that T-Cole has worked on. You want to explain that a little bit, TJ, a little bit further, and then we'll see if we have any questions on that.
Yes, sir. And this is similar to what we had in the last meeting. I think there's been some minor tweaks to it, but there are a lot of things, the administrative requirements, the policy requirements that are consistent across almost all types of those are at the bottom. At the top is where we try to deal with the challenge of different types of agency size and agency responsibilities. And so ultimately, what we determined is that looking at their roles and responsibilities is what differentiates their equipment needs, not necessarily the type of agency. So, for example, there's the fire marshal's offices that started doing more traffic enforcement. That's outside the role of what we traditionally expect from the fire marshal's office. So rather than defining the equipment they need by their type of agency, we did it by the types of responsibilities they're engaging. I think this will make it easier for agencies when they're setting up. One of the things that we've discussed over and over, we have a lot of school district police departments being created now. Those are one-man agencies with very limited responsibilities. As they grow, they will start to do traffic and pay cars and do other things. And as the responsibilities change, their equipment needs to change. So the goal in this is that we're able to get them started, they're able to meet their immediate needs, and as they grow, when they take on new responsibilities, that they equip and prepare their officers to have moved to operate the business.
Are there any questions or concerns with regards to the matrix that has been created to help agencies understand the requirements set forth through the statute?
And this matrix is of course tied to the rule. So this is, everything that's in here should be in the rule, at least in the same level of detail or more detail, but this was meant to be something simple. People can look at, understand the rules, something we can provide online, and when people in the setup process to think of it.
Sheriff, I'd just like to make a comment. I think that I really appreciate that approach, TJ, to this and to the committee, especially for my constituency. They perform a very vital function, and not all of them, as you say, will ever get to the point where they do other things outside of protecting that physical property of the students. Thank you for that.
And Chief, I'm sure you're well aware that the challenge a lot of times is not within the agency itself. It's explaining to the administrators above and people who explaining what those are. And so I hope that this will kind of make it easier to guide them through that and understand, hey, we can take on those responsibilities, and if we do, we have additional equipment needs or additional rules.
I think that our association and others can help get that message out and make sure that people understand it forward. I think that's then it's on them to make sure that you. So I appreciate it very much.
Yes.
I don't remember who originally came up with the idea, but I think these turned out very well. And I got to commend you all for making a wonderful product. Many of us are visual, and so this really makes it simple. But it comes time to present something to our governing bodies, and I think this is something that's it's gonna simplify things and puts it on a level that we as law enforcement are able to understand and follow.
That's what they.
Yeah,
It's not like it's a book.
and it's on a regular computer, about 11 by 17. And so, which is big when you don't have a printer that'll print that way. So, all right, if there's no other questions or comments, what we're going to do is go to the human right. Yeah. But in 2 days, we'll go any folders to go through and we can go through this document that everybody has. It's not through 11-229. We can go look at the changes that are highlighted on the different pages. Just remind everybody that if you're not involved in the conversation, make sure you're muted so that the others can hear as well.
So for those of you that are present, have copies in front of you, have two. One of them is 11 pages and one of them is 13 pages. They're the same thing. The 13-page one just has the strike through and underline to show you what's changed from the existing, whereas the 11-page one just shows you what the final product would look like when you take out all that underlying strike. So the 11 page is a little bit easier on the eye, but the 13-page kind of gives you where we're making change from the existing. The first pages are the definitions. And I've highlighted, these are all the definitions in our rule book, but I've highlighted those that are relevant to the rule that we're working on. In the last meeting, Mr. Wilkerson, we discussed the concern about some taser devices now being classified as firearms technically. So we just changed the definition of firearm. We added at the bottom of page 3, conductive energy devices, CDBs are not firearms. So for the purpose of everything described in our rule, it's clear that tasers are not considered firearms. You go on to page 5, where you have the definition for less lethal force weapon. This, of course, comes with the statutory requirement that every peace officer have a less lethal force weapon available to them. So rather than trying to put all that and explain it in the rule, we define what less lethal force weapons are here in the definitions, and then we refer to them in the rule. Of particular importance in this definition is, for the purposes of this rule of this section, it excludes firearms from being considered less lethal weapons. Doesn't mean that agencies can't have a less lethal shotgun. It just means that can't be the only less lethal weapon that's available to an officer. So if they have expandable baton, if they have before, if they have mace, if they have one of these other ones, they require the book. They can also have another firearm. They just can't be the sole weapon that you're relying on or the new rule. This does reference that an officer using a less lethal force weapon should be trained, qualified, and certified in its use. There's been some discussion about whether we should require that by rule. Again, a lot of this is local control. We trust the chief administrator to do that. We're making a recommendation. I think everybody is aware of the liability that taxes when you provide people with flood training for. So we're just putting the recommendation, the rule that trusting the chief administrator takes responsibility for side and ensures people are properly trained. Patrol vehicle is on page 6. That is a new definition. That is something that's also referenced in the statute as patrol vehicle, which was not previously referenced. We kept a pretty simple definition. This is the vehicle equipped with emergency lights, siren, and the means of safety containers for combative detainees. Again, we're not going to mandate that every agency has a page in every car. That's certainly the agency's decision and how they can take the transport, and they should have policy, and they should have the equipment. We're going to make it clear that if people have the responsibility of being on patrol, they should have lights and sirens to be able to transport somebody if they need. So again, we're getting the definition, we're making the requirements so that agencies know what's expected, but leaving them with the control to determine exactly how they'll outfit those vehicles. On page 7, we have sustainable funding sources. This came from, I think, Mr. Wilkerson's recommendation. This is something that there's been some discussion of, and this at some point goes a little bit beyond the expertise of people staff, rather than having been some year I think was valuable, but there was a discussion about where should that money come from. Funding from an agency's governing body such as property tax, sales tax, use of franchise fees, the issuance of traffic citations. We put the restriction of transportation code in there, which was brought up by this committee. We're trying to make it clear that term limited resources such as grants are not sustainable funding sources. So for those that are have not been to other meetings, you should. An agency needs to have sustainable funding sources to cover their operating expenses. They need to be able to pay their salary, fuel their vehicles, and pay the electric bill with sustainable funding. Grants can be used to purchase buildings, cars, equipment, to do other things. They just can't, you can't rely on a temporary grant to pay your bills. When the grant runs out, you will no longer be able to fund it. So this works in conjunction with the rule. The last definition we've added is uniform. And this is, again, it gives us a little bit of uniformity across the state, but leaves a lot of control to the chief administrator. You're going to write a policy. You're going to make sure that there's some expectation within your agency. Make sure that your officers we're working in, again, these certain responsibilities where they're visible to the public, they need to be readily identifiable as peace officers are. And that was the definition that we came up with, looking primarily for consistency across the agency. Going to page 9, this is the actual rule itself. So you can see the strike through to the old rule that we've removed and where we've made some changes. You want me to go through the rule, Sheriff, or?
Yes, please.
Okay. So the new section A talks about to establish an agency or prospective agency, and then it also references the continued operation. This is the change in statute. This is no longer just for the creation of an agency, but it also guides the continued operation of it. Number 1 remains largely the same, that there needs to be a public benefit to the community in order to create an agency. Number 2, the change came, and now instead of requiring that you have funding, it requires that you have sustainable funding. So that's why we defined it earlier to make it clear what our expectation, what Mr. Wilkerson helped us identify as being true sustainable funding sources. And then here we reference that it meets or exceeds the continued operating expenses outlined in the line item budget for the agency. So this is something that agencies have been doing in the past. They provide us a budget to show that they have funds and have a legitimate needs to support an agency. And this now makes it not sustainable funding. Number 3 is from the statute. It talks about the physical resources that have to be available. At least 1 firearm per officer on duty. We already had a definition for firearms in there. We didn't feel like we wanted to narrow this any further. Again, this is going to be largely the responsibility of the chief administrator. I know it's not telling officers what firearm they can carry and what they can't, but it's a great source of debate. So we want the agency to iron that out on their own.
So, can again, as we go through this, or you want to wait?
If you make your notes when we're done, we'll go back to work group updates and we'll go back and ask them. If you just want to go, you don't have to go over.
Okay, then I think most of this is the same as we went over last time. The less lethal force weapon, the radio communication devices, the bullet resistant vest, and the uniforms is all largely the same. The vehicles and patrol vehicles, the evidence room, again, the requirements for the evidence room is just consistent with been requiring up to this point. The dispatch area and public area, those are the same as last time. And we've got all the policies down here. I think we added one more to the policy, a few, which is training required to maintain licensure. That was a suggestion from within code. I think it's a good reminder for new officers to see in their own policy manual, a reminder that you have to complete cycle and unit training requirements so that they're aware of what's required to maintain their license. And then subsection 6 that talks about the administrative requirements is the same as last time. Particularly if you haven't seen section C in there, it identifies agencies that need to list a number of school resource officers. This is just part of our effort to make sure that all officers working in school have their school-based law enforcement certificate, either tracked by ISD police departments, right? You know they need it, but the agency that have school resource officers, we're not able to see that right now, and this would give us the need visibility to make sure that they have it. And then the last thing is that subsection B down here on page 11 talks about that anyone contemplating creating an agency would have to do some training requirement with us. That might be as simple as reviewing a information packet, signing off that they reviewed it, and then they can make an application for an agency. We added this F on page 12, and this is what we talked about, having some annual reporting requirements to make sure that agencies continue to meet those requirements. If the responsibilities change, that we ensure that they made the appropriate equipment changes to match those new requirements. And then if they stop reporting, so we have some agencies that become unmanned, right? It might be 1 or 2 man agencies. They go for a couple of years, there's no one there, they don't make reports, and after a certain period of time, that their agency will become inactive and they would have to resubmit and go through the application process. That's happening 5 years. We selected the March 1st date here based on racial profiling reporting. Every agency already has a reporting requirement then, so rather than create 2 separate reporting requirements, we anticipated would submit your racial profiling, your updated policies, your new budget, fill out whatever's changed from the year before, to do your report all in one. I think that helps ensure compliance with racial profiling, and it makes it easier for chief administrators where they know everything's going to be done.
Excellent. Thank you. All right, what we'll do now is we'll go down and we'll just kind of go through the changes. Yes, at first I'll ask you, anybody have anything with regards to the definition? If not, then come back to go ahead, sir.
Sheriff Watson, on page 5, item 39, less lethal force weapons. What would be the negative impact of change the word should, shall, in a sense? An officer provided equipped with a less lethal force weapon should be trained, qualified, or certified in use. Why not just go with more definitive shall?
So we've had that discussion, Chief, and one of the things that the sheriff and I have discussed, and I want to make sure everybody understands the contemplation of the enforcement of the. I get complaints, this is the major of the enforcement division of everything that every officer has ever done, every injustice that's ever occurred. There's a lot of officers who've been terminated who complain about the operation of it. So what I don't want us to get involved in is where we're receiving enforcement complaints because they're saying that their chief has an expired vest in the closet and they're always supposed to have current vests. And these are not meant to be disciplinary enforced rules, in my opinion. This is the requirements to set up an operating agency once a year. We'll check those things or have a bunch of expired vests, and certainly that's going to make it difficult for you to renew at the end of the year.
Yes.
But I don't want to be sending enforcement people out. It's the same thing with the training requirement. I don't have a simple means to keep up with every officer, every weapon that's issued, and whether or not they have the required training for each individual weapon, right? So whether your officer's been trained with the PR-24, whether he's been trained with OC spray, whether he's been trained with the taser, I expect the chief makes sure of that. If we put shall in there, that would lead people to believe that they can complain to me that one of your officers is carrying a taser when he hasn't been tasers. Does that make sense?
It does make sense. There was part of me that actually thought you would do that on a situation like this because it's narrow and specific with less lethal. I haven't done a bunch of audits for TPCA. Compliance is a very big deal. Again, that is a voluntary compliance organization. We have no disciplinary thing other than removing their accreditation, which would be a big deal for the agency. But that trying to get agencies to comply with consistent training standards for very important. It only takes that 1 week to become baton certified, 40 hours of education. I understand your point. I understand.
And I don't see a reason that we won't check that, right? When we go, and if you have less lethal shotguns, can you show us that those people are trained at the time we're doing an inspection? I just don't want us to be fielding where someone is complaining because they think that one officer isn't trained and he might have been in the car that had a less lethal in the trunk that day. And we need to launch an investigation to see if they're compliant.
I yield to your experience, Pedro, and I appreciate what you.
Yeah, he had the exact same question that I did last time we had a discussion. So, but after visiting with the major and the legal counsel, and then some of the enforcement folks that are out on the street, T-Cole going out and conducting them. Yeah, I agree with the major that it just becomes a logistical issue that's going to turn into something that's never in the first place. So, same thing. I was like, all right, I yield to you on that. Yeah, Bob, go ahead.
If you had to go to court, how do you think you stay on?
I'm sorry, can you say that again?
You had to go to court. How do you think you would stand with the changes that you were made?
If I had to go to court, how would I stand with the changes?
Yeah.
In what way do you mean, in what way do you mean, Bob, like civil or criminal or?
What do you think you would stand? Do you think you'd be the winner or the loser?
The state has final administrative rule power over local jurisdiction. And so once it's gone through the process, then it is the law of the land. And there's not going to be any issue with it, because once it's gone through the system, because the legislature is the one who says, come in, look at this, make recommendations for changes. Us as a body works with T-Cole to make recommendations for those changes. Then it goes through the process of going to the commission to be adopted. And once the commission has it, then it's going to go in front of more public, public input. And then once it's set in stone, it's finally due there, then the commission is pretty much, there is no legal side to it other than we're required to do it. And if we don't want to do it, then we don't get operated as law enforcement. Our governing body just replaces with somebody who does it.
Okay, great.
And the chief's brought up a really important point. If we go to an agency and they're using a particular type of weapon, and we ask to see the training records to make sure those people are trained, and there's a couple of people that aren't, and in the report we document and we make a recommendation to the chief that those people get trained as soon as possible. All the chief administrators are aware of the civil liability that attaches to allowing someone to use a weapon they're not trained in, right? And once it's been documented, I think that pressure becomes that much bigger, right? Chief?
Absolutely.
It's absolutely a recommendation. Now it's in writing. I'm going to make sure before that person goes back to work that they get that training. So that's kind of our role, is to help police that, if you will, right? Help them identify things that may have been overlooked. As agencies get bigger, sometimes chief administrators are unaware. If we find during the audit, make recommendations, it only gets corrected.
So I have a question about less legal also. So I understand where you're coming from, and I like the options. When something else is developed, like in our business, we're seeing a lot of what we call the BOLO, which is around, and it uses expandable gases. I mean, so to send that projectile out, I'm assuming we can rely on this definition of a taser to look at other things that don't send out a projectile that can injure or damage someone.
Right. I think that Mr. Wilkinson's concern, and you probably know more about this than I do, was it an ATF classification of a certain?
Does, the definition of is discharge of a piece of property, basically. And I think, Chief, where you're going, I think, the first steps that they're concerned with the design or intended to use of individual groups or individuals, which of course expected or reasonable for seeing these.
Yeah, I agree. I just wanted to throw that out there. There's a lot of school people listening that would ask about that.
The last thing is, this is not meant to restrict anything that chief administrators do.
I
This
understand.
is defined as one of the weapons.
And I wanted everybody to hear.
Right, and like we talked about last week, with people that weren't present, I think it was the intent of the legislature that you have something between grabbing and punching people and shooting. You gotta have something in the middle. And I think most of the people in the room have multiple options in between, and they're well within the rule, but if there's an agency that doesn't have, it can't be a firearm, you have to have one other option.
Agreed, thank you.
And I think that's.
Good.
And I think we're gonna have to respectfully agree and disagree on this one, PJ, because the way I interpreted the legislative intent was, especially after the Austin basic riots, there was a lot of confusion, a lot of concern about those. And from my take of the session, the intent of the legislature was to give people that oversight authority of these officers are not trained in this, and TICO should have the ability to take some kind of action against them. That being said, I also understand the state legislature did not give TICO the funding that would be needed to accomplish such a task. And I think it would be unfair for this committee to impose something like that on TICO when the legislature did not give the bill from entities. So I just wanted to point that out.
And the challenge in that is not just the position, but it's how we get that information. Right? We don't have that level of granular detail. We don't know what rank people are within your agency. We don't know what weapons they carry. We don't know what their assignment is, or we would have to know a lot of that information in order to turn out. So if that's something the legislature contemplates, give dramatic shift in what we do. In your annual report, basically, I think you have to update regularly. Every time someone changes assignments, or promoted, you have to report that to people. Every time they got trained or put new weapons, you report that to people. I think that goes well beyond the scope of what we're trying to do.
Anything else on, definition number 39? Let's wait till, first part. If not, any other definitions that are in here that anybody has any questions or comments with regards to?
Mine is kind of related to the definition of looking, go to page 10. Talk about the evidence room of acceptable evidence storage. I believe you can probably know me out on this. I know a lot of agencies are trying to get that PCA accreditation. That is, that's a major issue that they're going into evidence.
Yes.
Should we define what acceptable is and maybe still the definition from TPCA as far as who that is? Thoughts on that?
Well, what? Phrase this carefully. What TPCA is looking for is literally a secure adjournment, control access, limited numbers of people out there, and a lot of people in and per video camera. We go in and we audit to make sure that if you have 1,000 items in the property room, that we have 1,000 reports that match up to that. We sample, we don't check all 1,000 items, check 20 to 30 items, right? And make sure that they're in there. I mean, could we? I'm biased towards that, so I would say yes. What we don't want to see is evidence being kept in hallways or wire baskets or closets and drywall rooms and stuff like that. And that does, I mean, I can know over agencies where we keep all our evidence in a 6-panel, $11 door with a really important, and there's cocaine and laying on the other side of that door.
And also talking more of the structural, not the policies are, and more than business.
So we would be supportive of that. I don't know how the committee would go.
That wouldn't work well for.
One of the discussions we had early on was the fact that some of the schools lack the space to have a dedicated evidence room, and they purchase a safe or something like that. So that was something that didn't come up in some early discussion.
That's how it's being applied right now in our inspections. If they don't have an action secure evidence agreement, and remember, most of these agencies are a startup, right? It's a one or two man agency. So they do a starting equipment. Is that they're required to have a large gun safe at the bulk of the floor. Usually it's in some room that has some level of controlled access. Generally, it's the chief administrator's office. So he has access to the safe that's within his office. That's how most of them are set up. I think the challenge becomes when we start defining some of that, when they run into situations where they're not able to meet that and we're kind of boxed in. Some agencies get an MOU, so they'll start a small municipal agency, they'll get an MOU with the sheriff's office, and they store all their evidence at the sheriff's office, and they're already meeting a lot of the requirements that you're talking about. So sometimes simpler and more cost effective. The situations that you talk about, you're saying hopefully you're not going to be done an inspection lab at the start. They somehow got there since they started. And that's been the challenge. It was a requirement to start the agency, but not an ongoing requirement to maintain the agency. Yes, sir. This is new. So I would expect that what we're holding the new agency to will not.
I have a question on page 913, where we talk about at least firearm, one firearm per officer.
Well, I tell you what, let's go down the list. Yeah, short consideration. We all mind. We'll go ahead and start with, item number 1, which is determination regarding the public benefit of creating an agency. Anybody have anything on that? Then we can go down and touch all of these. If not, item number 2, which is the sustainable funding sources for the agency. We have the changes there. They're in there. Does anybody have any questions or comments on that?
That'll go, that's listed on page 9 of 13, number 3, at least one firearm officer on duty. So the question is going to be, any agencies have a list of acceptable firearms the officer provides them. No way are we saying that the agency is now required to provide a uniform firearm for each, or adopt a single.
Right. I don't think that that's reasonable. There's just too many differences. This is one where we wrote all different kinds and we came right back to what the statute said. The question became at some point, if they have a high point pistol, it's in the drawer, when you come to work, you get out, put it in the belt, when you're done, you come back in the drawer, the next guy gets it, is that acceptable? And I think that meets the requirement of the law. I think that we have to trust the chief administrator to determine what's best for their agency, how they can qualify to put them. Some agencies have a means to purchase them, and then some let the officer buy their own. That should be up to the chief administrator.
To echo that a little bit further, what you're describing is an agency on a high point. And the chief's concern, the sheriff's concern is by point text. I'm going to read this to say that the agency must provide at least that one firearm that everybody's coming and checking out. And you have some agencies that either tell their officers you can purchase your own firearm, or you have some agencies that engage in contract negotiations with their employer. Houston is a great example. City of Houston, they did not provide a firearm in their contract. They received stipend. So, sheriff chiefs, service on this, want to make sure it's opened up that whatever that local entity determines is appropriate. And I read this and I think a lot of places are going to read this to say we have to find a firearm.
And that's the question I've been given. The feeling is, it says we can at least one firearm per officer in duty. So my agency provides, we adopted a single firearm and we provided for the officer, so that's not an issue. There may be the one or two that is an issue. I agree.
So should we add on to that sentence that at least one firearm per officer on duty unless the officer is required to provide their own firearm performance if they're police officer or something like that.
I just think it needs to be clear that if the intent, I don't believe it is either. I believe the legislative intent was that the agency has to buy firearms to give. And I think that we just need to say that it's not, they are not required to purchasing. The agency is not bound by purchasing, providing. Something like that. I think that's where we're going to stumble. I agree. That's the way people that we go out now. And we don't want to buy one, we want to have a list and choose off that list. That's my concern.
Well, has physical resources available for the means to make it?
But I don't think we want to change it there. I think we'll change it in the A. Yeah, just define the firearm as either owned by the agency or by the officer or something like that.
Yeah, well, that's where I'm looking at is on A2, A3, A3A.
You can change it, Bob, and you're changing everything.
Yeah, you're changing everything. It's A3A is the one that I think has to have a little clarity to it. Go with that.
Oh, yeah, you have to,
You have to do
every weapon you carry, you have to be carried and certified. Yes.
And qualified agent.
People get the call, people are,
Before you carry on duty. That's a
Some agencies wouldn't allow them to do that. That's the thing. Some don't, some do. And that's that local control to determine which works best with the agency.
And I always go back to, when I was young, they issued us, when we first got the locks, they issued us Glock 21. Our chief of police, tell them how water you were carrying a Colt 1911, anything so flash, you just personally didn't like. And so you have some agencies that are that way. But under state standards, we have to qualify for every weapon that we're going to carry before we carry.
So I don't know if y'all can see it there, but 3A would now read at least one firearm per officer on duty, comma, provided by either the officer or the agent.
There you go.
There you go.
That works.
So
That works. Thank you.
We've already gone over less lethal. Does anybody have anything else on that? And then under E, we have uniform and Jeep patrol vehicles. Anybody else have anything else under the number 3, the physical resources available to officers? Hearing none, we'll move on to number 4, the physical facilities agency, including evidence room, dispatch area, and public area. Are there any further comments with regards to number 4? Hearing none, we'll go on to number 5, the policies of the agency, including the policies that are listed here, which of course we know that, we've made some additions in there. And so does anybody have anything with regards to any of those additions or changes?
I'm sorry, Sheriff, I do have one. That's also 4C, the public area, including written notice and posted visible 24 hours a day. So again, we're saying if an agency doesn't operate providing services to the public, although a school would be considered a public place, they would not be required to meet this standard.
They would have to have a poster. It's almost like our complaint.
That's a complaint process, but we don't have a public area for the police department. We don't have a building. They're in the school itself, and they have to, and the same thing with, now, Chief Cook has a large facility, it's humble, but we don't in East Texas. So, and our dispatcher, although I'm a licensed telecommunicator, I don't operate in that.
So this, again, one size never fits everyone. That's the challenge that we have. We have a lot of police departments that operate certain hours of night and stuff, and there's no one there. The sheriff's office went. The intent is if someone goes to the police department for help, when they get there, there's something that tells them who to call if there's nobody there at the police department, how to handle this. I think that a school district, if yours is within this school building and the building is locked and secured, I think you have some similar sign in the window so that if anybody in the building came to the police department looking for help, they would know how to do it. But yes, you're right, people outside the building and let them know now.
Yeah.
The intent is just. to-
Agree.
When they go there, there's nobody there, they know how to get the most immediate help, and they know how to make the report if you're outside.
I think Chief, that's so Chief.
Good.
Chief Cook?
Yes, sir.
Yes, sir. Did you have some, sir?
No, I was just agreeing with that. You know, it needs to be posted where the public can view it even after hours.
Thank you, Chief.
Also, excuse me, I'm having bad reception here. I was going to comment on the bowler wrap that Bill mentioned, and I couldn't hear if he mentioned it, but bowler wraps are considered to be firearms.
Okay. Thank you, Chief.
So just to add to that, there in the public area. If you don't know, they're thinking about this, we don't have access to our building. But to accommodate that, my plan is to really put our, public meeting notices, part of our statute to have that anyways. We're just getting posted right there, so I think even if they don't have that 24-hour facility, we can still post and meet this.
But if someone came to that building looking for police assistance, they would at least know what I need to do right now.
We're going to refer people to the local PD or this, so maybe not. But it doesn't really matter. That works. Appreciate Sheriff. Thank you.
No problem. We'll go back to number 5 on the policies. Are there any questions or comments in regards to the policy?
The only one that I would recommend putting here, I'm not seeing it, but yeah, right here, struck out any other information the commission requires. I do think we probably need to keep that language somewhere in there. Because if TCO decides, if the commission decides that each agency needs to have this policy in the future, would we need to come back to this rulemaking process to get that amended? As opposed to keep that language in there in addition, then now we don't have to go back through this TCO to do it on there. Does that make sense?
It does. So we move that in, either leave it at 8, move the other one to 9, or is that how you would do that?
I think what we would do is any other information the commission requires would become now.
And I do apologize on this numbering on that. I think we also need to five. The statutory requirements for the market, not a addition process that needs to be taken. The automatically included in there with those mandatory policies. But the legislative things that makes sense, says agencies have to have this policy.
If that happens, I don't think there's anything that prohibits us from gathering that policy, and we would need to go back so that they know what it is. And I think you're capturing that in 9 by adding that. So the way I've changed it now is 8.7 reads has liability insurance for the agency and its vehicle. 8 reads has a defined process by which the agency will receive by mail, online, by phone, document compliments, complaints on its employees, and then 9 reads any other information the commission requires. So that captures, like you were saying, that's required for one new policy. Do it with that until the new change delineate it to everybody else.
Okay, it looks good.
No, those are helpful.
No, we appreciate it. Mary. All right, so going down, it's, with regards to the other changes there, we have, are there any other questions or comments or recommendations with regards to any of this under this section? I agree with T. Cole with making it same timeline as the racial data profiling is going to simplify things so that the fewer deadlines we have, the better off we are. For stop for very.
Sheriff, I do have a question on item F on page 12, all law enforcement agencies, the March 1st reporting. Will there be a equal template like we do racial profiling? I mean, we still have the option of uploading our own racial. But will there be, or is it just going to be a checkbox that says, yes, we're in compliance? Or do we have to submit a report that we create?
You will not be required to create the report. I can't tell you what it's going to look like yet because we don't know yet.
Okay.
So what I envision, what I hope is that the initial application will be an online process. And then each year you will go back and update, kind of like TurboTax, where you can see your information from the year before, and you just update certain information and you submit that. Attach your new racial profiling information. If you change your policy on active shooters, you attach your new policy and then you save the information.
Okay.
But you can imagine with these different advisory committees, we have a lot of needs. We're going to be collecting a lot of information we have in the past. We're building a lot of systems, in particular to hold confidential data associated with officers. So those are our priorities right now. The implementation of this might take a year or 2 years before we start collecting that data. But the expectation is that it will not be difficult, that it will be something that the agencies can go through and do after racial profiling and be done with all.
Okay.
So with that being said, with the effective date,
The effective date would just be for the rule, and we're, obviously, I have March 1 in there, but that's probably not. That will change based on how the commissioners vote. They'll have their first vote, there'll be a public comment period, we'll have the final vote more. The effective date is just last opinion.
so we're going to sure that every agency is going to go back and find some much.
And again, this will be the effective date of the rule, but the implementation by TCO is expected to take longer. One of the things that we've already contemplated is that there are agencies in the process right now of setting up new agencies under the old rule. And we're not going to change the goal line on it. So we're going to have to set a date where, right, if you're going to activate before this date, you're in the old rules and activate under the new rules, and everybody gets an application in the way. We'll either make the deadline or they shoot for the new rule to make it compliant. I would hope, because it's an ongoing requirement, that we just go ahead and participate on it. We don't want to stop anybody from these days away from initiating an agency.
The chief is going to be so happy. There's another form we fill out.
I still think Martin Burke is for everything.
Are there any other questions, concerns, or comments with regard to the draft of the rule changes? If not, then what we'll need to do, talk to the major, is need a motion to authorize presiding officer to consider for changes to the commission consideration. Is that correct? Is that how you,
Or to present the draft rule, I think. Is everybody comfortable with the two minor changes I made? I can be confident that everybody get that.
If you can just email it to us, then.
Okay.
That's second.
we have a motion, a second. Do we have any discussion? If not, all those in favor? Aye. Are there any opposed? No, hearing none, the motion passes. So, we'll move on to item number 4, and I don't think we're gonna have anything, but discussion and action on future advisory committee meetings, things would be. So I guess unless something special comes up, that TCO lets us know that this will be our final meeting. And we will move on to number 5. Receive public comment on any topic. Always remember that there's a public comment section coming up, or a timeline coming up, where official comment will be able to be made by email to TCO in order to have some additional input to this, in case there's some changes that need to be made. Does anybody that's here have any comments or questions?
I like the area of radio, the culture matrix.
They did an outstanding job. Thank you. All right, if not, then I'd just like to thank all the members of the board for taking their time and working on this. You know, did an outstanding job. That's a lot of questions, a lot of things I never thought of in my career came up. So I really appreciate it. It's educational for me. I'd like to thank all the members of TCO. Done an outstanding job of working with us and helping us through this process. creating an outstanding document that's going to be very useful. And then all of the agency heads who came and provided input and who met with us practically on our side. So thank you all and appreciate it. T-Cole, outstanding professional organization. We thank you very much for thank you. So, thank all of you. So if not, do I have a motion to adjourn? I don't think there'll be anybody opposed.
Really.
Yes, sir. I'll email you. Thank you all very much. Everybody on the conference call, we appreciate it.